Thank you, Madam Speaker. It's 2:30, but I'm glad to see that the front bench is there. The Honourable Minister Mento is there, and the Prime Minister, which shows the importance of this motion. This motion has at least enabled us to hear another side of the story. Because as I'm going to show later, what has been said today in this House by the Honourable Attorney General is very different from what the same Attorney General stated in his press conference to justify the reason for making the payment to Honourable Dayal. And let us also be clear, Madam Speaker, that we on this side of the House have nothing personal against the Honourable Attorney General, Manish Gobin, who, like myself, is a barrister, and I've known him for a long period of time. But we are not agreeable that this government has come, and we know now that it was a cabinet decision to the whole government approve the ex gratia payment. We're not agreeable that they approve the ex gratia payment of 15 million, just like we're not agreeable that the former Commissioner of Police made an out-of-court settlement, because as I'm going to demonstrate to this House, there was absolutely no reason to negotiate or pay a penny, a cent, to Mr. Raj Dayal. Madam Speaker, the Honourable Attorney General started by reminding us of the very important nature of his constitutional post under Section 69 of the Constitution. He is, and I quote, "There shall be an Attorney General who shall be principal legal advisor to the government of Mauritius." So he is a principal legal advisor to the government. So when he goes to Cabinet and tell Cabinet that we are reaching a settlement with the former Commissioner of Police, he is wearing his hat as the principal legal advisor, and he's giving his legal advice. And the provision of 69 of the Constitution is very clear. You can't be an Attorney General without being a member of Parliament, but you have to be a barrister. If you're not a barrister, you cannot be Attorney General, because your main role is to advise government. And it is that respect, Madam Speaker, that we support the motion, because we feel that as the principal legal advisor to the government, the Honourable Attorney General erred when he recommended and that Cabinet approved the payment of 15 million or so to Honourable Dayal. Madam Speaker, Raj Dayal was not anybody. He was the Commissioner of Police. And I wonder how many of the orators, how many people in this House, how many ordinary members have taken the pain to read the 3 plaintiff summons which was lodged by Raj Dayal against various parties, against the state, against the Commissioner of Police, against the Commissioner of Inquiry, the members of the Commissioner of Inquiry. How many took the pain to go and read and understand what was the nature of the cause of action of Dayal against these people? It all boils down to one thing. He contested his dismissal as the Commissioner of Police. That was the basis. In some, he said that, he suffered personal damages, his parents suffered personal damages, his family suffered personal damage, but the facts remain that all his cause of action is rooted under one principle: he ought not to have been removed, suspended, removed, faced by a Commissioner of Inquiry, faced by a tribunal. His removal, dismissal, was unconstitutional. And he repeats it several times in his 3 plaints. Now, a Commissioner of Police enjoys security of tenure. You can't remove a Commissioner of Police just like any other civil servant. And the Constitution is very clear, Madam Speaker. It is found in Section Section 93 of the Constitution, removal of certain officers. This section of the Constitution concerns removal of the Electoral Commissioner, the Director of Public Prosecution, the Commissioner of Police, and the Director of Audit. 4 key constitutional positions which has security of tenure and cannot be removed, unlike other civil servants who can be removed when there is a change in government. There is a provision in the Constitution which allows the Prime Minister to remove civil servants and appointees appointed by former Prime Minister. But in case of these 4 people, the Constitution is very strict. So the question that we have to ask ourselves in this House: was the provisions of the Constitution followed in respect of the former Commissioner of Police? And it was followed. If it was followed, why are we compensating him for having been removed as Commissioner of Police? Now, what does the Constitution, Section 93, provide? Section 93 provides that, first of all, you need to have a commission, the Discipline Forces Service Commission, who has to initiate the whole proceedings. This was explained very clearly in one of the many cases which Honorable Dayal brought to court. One of them was against the President of the Republic, and that was explained very clearly. So, unlike what the government is alleging, this process starts by the Discipline Forces Service Commission. If the Discipline Forces Service Commission feel that there is ground, he refers the matter to the President of the Republic. There's only 2 grounds. Either the Commissioner of Police is unable to discharge his function by infirmity of body or mind or other causes, or for misbehavior. So the Disciplinary Forces Service Commission writes to the President and say that, please, we think that there is sufficient ground to set up a tribunal. Then the President, acting in his own deliberate judgment, and Rajaya contested the decision of the President to set up the tribunal. He was thrown away. Thrown away. He appealed, thrown away. Privy Council also nothing. Everything was stated in the Supreme Court. You cannot challenge the decision of the President of the Republic, acting in his own deliberate judgment under Section 93(4) to set up the tribunal. So first, the Discipline Forces Services Commission informed the President of the Republic that there are grounds to remove him, to set up a tribunal. Second, the President of the Republic sets up a tribunal. And he sets up the tribunal, and the tribunal is chaired by the former Chief Justice, Raj Lala. And then he has 2 assessors, because the Constitution says that you need to have a chairman and 2 assessors, at least 2 assessors, who has to be sitting judges or former judges of Mauritius or of the Commonwealth. So the strong tribunal consists of late Raj Lala, former Chief Justice, Mr. Histoparsad Matadin, actual Chief Justice, Honorable Matadin, and Honorable Paul Lam Shangming, former Justice, and now the President of the Commission of Inquiry on Drugs. And Madam Speaker, I pause here to note that the Commission of the Tribunal was set up after the Commission of Inquiry started. The Commission of Inquiry actually was set up on the 10th of October 1997, but the tribunal was only appointed on the 23rd November 1997, 1 month later. Why? Because when the Commission of Inquiry was set up by the then President of the Republic, chaired by Honorable Sikwen, he was Senior Punitive Judge, number 2 of the judiciary at that time. He had as assessor Mr. Kuldeep Lala and Mr. Lashminarayan Ramtuhal. That Commission of Inquiry did not have as mandate to inquire on misbehavior of Dayal, of the provincial police. No. In that time, there was a series of articles. I remember very well, I was in Mauritius. Week in, week out, all the press was talking about scandal of the gate. Contract awarded to Kalaniketan. Too late, Mr. He now passed away, Ramrakia. And it is interesting, Madam Speaker, when we read the report of the Commission of Inquiry. He lists out the terms. The Commission had to inquire contracts awarded by the police department, and in particular to Kalaniketan and to Ramrakia. And the Commission says, they interviewed a lot of people. And then at point 3.2, this is what the Commission of Inquiry said. Another major witness was the Commissioner of Police, Mr. Jareswal Raj Dayal. The Commission spent considerable time in questioning him, and he turned out to be the main witness. So before that time, no one was targeting Raj Dayal. It is when he came and there was a Commission of Inquiry, when information started cropping up, that the Commission of Inquiry made this remark. And then what the Commission of Inquiry goes on to state at paragraph 4.3 of the prologue. We cannot help remark in contrast that in spite of the fact that a Commission of Inquiry had been appointed to inquire, amongst other things, into the matters set out in paragraph A of the terms of reference, Mr. Dayal stayed in his office as Commissioner of Police until he was suspended from performing the function of his office following the appointment of a tribunal pursuant to Section 93, subsection 4 of the Constitution, to investigate into a number of charges leveled against him. So the Commission of Inquiry, when they started investigation and they continued investigating, Honorable Dayal was still Commissioner of Police. So the terms of reference of the tribunal was different from the terms of reference of the Commissioner of Inquiry. In fact, in one of the cases, because there have been so many cases, I came across the charges. There were actually 15 charges. 15 charges which the tribunal had to investigate. Some of them related to lying before the committee, intimidating witnesses, but others had to do with, increasing the number of units of disposable ammunition, failed to make arrangements for training police personnel, failed to ascertain whether a local supplier was holder of a license, failed to inform the government that local agents were involved in supply of firearms, failed to follow investigation related to case of assault, involved in events which have been prejudicial to law and order and to racial harmony, mishandle and make an abuse of power in the inquiry created by the Secretary of Home on disclosure of classified information, attempted to intimidate and induce police officers. So there was a lot of charges which was before the tribunal. And tribunal, as I stated, Madam Speaker, is an extremely strong tribunal. With Mr. Raj Sumer Lala, with Mr. Matadin, with Mr. Lamshandin. And that tribunal found him guilty as charged, and under Section 93 of the Constitution, 93 subsection 3, any such person, meaning the Commissioner of Police, shall be removed from the office by the President if the question of his removal from office has been referred to a tribunal appointed under subsection 4, and the tribunal has recommended to the President that he ought to be removed from office for inability as aforesaid, or misbehavior. So when the tribunal comes and makes the finding and recommend the removal, the President no longer acts on his own deliberate judgment. He is bound by Section 93, subsection 3, to remove the Commissioner of Police, and that's what he has done. And the Commissioner of Police, and the former Commissioner of Police, Mr. Dayal, entered numbers of cases. Whatever you can imagine, whatever legal point you can imagine, he entered. He lost them all. Until there was this case before the Intermediate Court. The Honourable Speaker before me, Honourable Ratna, made a lot about this case before the Intermediate Court.
If my learned friend will give way, I'm listening very carefully to what my learned friend is stating, and before he moves on to the judgment of the Intermediate Court, I was eagerly waiting for my learned friend to give any indication of the document from which he was quoting from his beautiful iPad. It appeared that he was quoting from a particular document, but I could not hear him say which document it was and whether it was a judgment or a finding, a particular, and could he provide it? Because as the leader of his party stated, we all want the truth in this case.
Sure, Madam Speaker. As I said when I started, there was a number of cases before the Supreme Court, and this, what I've quoted, was from the case of Raj Dayal against the President of the Republic of Mauritius, reported in 1997, SCJ, page 417. It is a decision by the then acting senior penal judge, Mr. Vinod Boulel, delivered on the 5th of December 1997. So he set out the charges. In this case, just for the benefit of the House, what happened is Honorable Dayal sought to get an injunction to prevent the tribunal from hearing the matter on the ground that he was not communicated the charges on the day he was suspended, but he was communicated the charges 5 days later. So that's why the judge set out this.
Is that the point of clarification?
No. The point of order still.
I'm sure the honourable member.
No. If that, no, then there's a, if that was an application, and I'm sure it was an application for injunction to prevent the tribunal from proceeding with its hearing, I heard my learned friend say in his speech, while quoting from the iPad, that there was a verdict of guilty on all those charges he read. It cannot be so in an application for an injunction.
The charges that was the charges is what I've stated. Okay, so am I to take it that today the Honourable Attorney General, is challenging the finding of the tribunal and the decision of the President to remove the? No, I want to know, because if this is the case.
Order,
this is the case. This is very...
Order, please. Honourable Attorney General, please. I think there are other members on this side of the House who will intervene, and they will be able to make the case. Please.
Yes, Madam Speaker, the reason I find that very objectionable is that the Honourable Attorney General started by bragging, by saying, yes, I appear before the tribunal for the state. Yes, I won. But if you won, so you know you helped prove those charges. So today you're coming here, this House, and you're saying that you won but you didn't win?
That is very unfair. The point I'm making is, if reference is being made to a document, like other honourable members intervening before the honourable member now, produce the document. Yes. I again repeat, like the leader of the party of my learned friend Uteem, we all want the truth. So table it. This is my point. We all want to see clearly what happened in the case. If reference is being made to an injunction case, so be it. If reference is being made to the findings of the tribunal, so be it. But let us be clear and let us all be cool. Yes, I also agree.
Will you be prepared, Honorable Uteem, to table a copy of the document under reference?
I don't have any problem tabling the copy of the cases, but I'm sure that the honourable member have this case, but I don't have any problem to table this case.
Okay. Please,
Yes,
please.
so let's now move to this famous case of the charge before the intermediate court. Yes, there was a case. There was, in fact, 3 charges, and I'm reading from the Director of Public Prosecution versus Dayal and Ano, reported in 210, SCJ page 314. That was the appeal case. So in the appeal case, they make reference to the finding of the magistrate case. And in this case, Madam Speaker, the judge summarized the count under which the Haji Dayal was prosecuted before the intermediate court, charged with giving false evidence before the Commission of Inquiry, charged with forgery, charged with offense of conspiracy, charged with false evidence giving false evidence before the State Commission. So that was what he was being prosecuted for. Nothing about the other finding in the Commission of Inquiry. And I'll come to the finding in the Commission of Inquiry just now. So he was charged because there were allegations made that he forged documents, he intimidated witnesses before the Commission of Inquiry. And the case was dismissed for the grounds which has been already dealt with by Honorable right now. But I just want to put a comment. The trial judge made it clear, I'm quoting from that, made it clear, talking about irregularities, okay, on what the respondents put forward as being serious irregularities. The trial court, the intermediate court, made it clear that each of them taken individually would not have been sufficient to warrant a stay of proceeding, which is considered as being an exceptional measure. However, they were, of the view that the conduct of the inquiring authorities was of such a nature that when those irregularities are taken together in the light of the nature of the charges against the respondent, that it was unfair to try the respondent, and the Court of Appeal did not find any reason to interfere with this judgment, with the finding by the magistrate court. But the decision of the tribunal has never been subject of any dispute. Dayal, former Commissioner of Police, was never prosecuted for anything to do with his dismissal as Commissioner of Police, and then he won the case. No. No. He won the case where he was being sued for having misled the Commission of Inquiry, for having interfered with witnesses, and he went, like rightly pointed out by Honourable Mover of this motion, on technicalities, not on the fact. There was no finding that he did not interfere with witnesses. There was no finding of fact. There was, the case was dismissed because the magistrate thought it was abusive to leave it to continue. But no finding that he was wrongly dismissed as Commissioner of Police. Now let's come to the Commission of Inquiry. I am not going to repeat everything which the mover of the motion said, and in fact, I have to say that it was much more because I took the pain of reading it, and frankly, Madam Speaker, I can't understand how honourable members from the government are clapping when we have given this person 15 million after what the Commission of Inquiry has said he has done. Yes, and the Honourable and Raj Dayal. And Raj Dayal was not happy. Raj Dayal was not happy with what was in the Commission of Inquiry. He was not happy. So what did he do? He applied for judicial review. He applied for judicial review. And this is a judgment. Reference Honorable Attorney General Dayal versus Honorable Yan Sikuen and others, reported in 2002, Supreme Court Judgment 263. He applied for judicial review. 1, 2, 3, 4, 5 pages. 5 pages of grounds for challenging the judicial review. And then what happens? At the hearing, learned counsel for the applicant, for Mr. Dayal, only pressed ground 1. Only pressed ground 1. After all that they said, you know, this eating, this sharing of tamaron, these people from automobiles coming and alleging that they've given bribe. Not a word, nothing to challenge any of the facting. He came on pressed for only ground 1 relating to ultra-virus and the ground relating to the alleged overpayment to Jihad. And then this is what the learned judges said. We consider that his approach is to be commended, since having thoroughly examined the evidence on record, this is finding of fact, having thoroughly examined the evidence on record, in the light of the satisfactory explanation furnished in the affidavit put in on behalf of the respondents being Honorable Sikuen, Mr. Lala, and Ramtohel, the members of the Commission of Inquiry, on the satisfactory explanation furnished in the affidavit put in on behalf of the respondent, we do not consider that there is any substance to the other grounds. Not me, not Labour Party, not mover of the motion. We are talking about Honorable Pillay, Honorable Pillay, Chief Justice, Honorable Pillay, Chief Justice, and Honorable Narayan, Judge, 2 senior judges who come and say that there's nothing, they have perused everything, all the affidavit, there's nothing on the other grounds, all of the other grounds. So all that was said in that Commission of Inquiry report is true. This is a finding of fact. I'm not giving away, Madam Speaker, unless it's a point of law. He can intervene in some here.
Is that a point of clarification or is that a point of order? If it's neither a point of order nor a point of clarification, then I don't think I can give you the floor. Can you please?
Yes, and then even on the grounds raised, I'm not here to defend Rambouillam. I'm here to defend Honorable Sikuen. I'm here to defend Honorable Raksoume and Lala. I'm here to defend Honorable Matadine. I'm here to defend Honorable Lam Sanlin. I'm here to defend the people.
Order, please. Order, please. I'm announcing. Please. Let me say that the honourable member has the right to make his points. But he has the right to make his arguments. He's got the right to talk and make his arguments. Others will have the right then to reply to his arguments. Please allow him to proceed in silence.
Thank you, Madam Speaker. I was talking about the judicial. Even on the first ground, okay? On the issue of temple, collection of money in the temple, this is what the honourable the judges say, that the respondents, Commission of Inquiry, had acted ultra-virus and exceeded their mandate by investigating into the affairs of the temple. So he won this point. The Commission of Inquiry should not have investigated on all the small rupees and cents that was collected in temple. He won on this. Then, on the point of, we consider that the respondent had also exceeded their mandate with respect to 20 generator sets. Again, allowed this. The Commission of Inquiry were wrong to deal with the 20 generators. But, on the other point, we are of the view that the respondent were perfectly entitled to inquire into a contract entered between the police department and NBA and make appropriate findings. So, his claim dismissed. We also consider that the respondents were entitled to do this, dealings with free meals, in line with the terms of reference. The application is otherwise dismissed. So this is what was said by the Supreme Court on the Commission of Inquiry. Everything else was stated to be proven. The judges said that they had perused the affidavit. They find no reasons, no basis to set aside the other recommendation, the other finding of the Commission of Inquiry. Now, Madam Speaker, I heard the Honourable Anurud Jagnat talk about the mentor, talk about victimization of Mr. Dayal. Let me quote from a paragraph 20 of the plaint written by Honorable Dayal in the case in Lite, the case where he is suing government for 1 billion rupees damages for him and his family because of the Commission of Inquiry's findings and the fact that he has been removed by the President of the Republic. This is what he said. He said that on 19 February 2007, Raj Dayal made representation to the then President of the Republic, 2007, arguing that his removal as CP was made in an arbitrary, unlawful, and unconstitutional manner. And referring to the cases which Honorable Ratna had just mentioned, the case of Intermediate Court that had dismissed his case. What happened then? I don't know. Honorable Attorney General, this is from the plaint. I don't know the veracity, but this is on the plaint of summons which was served on May 2014 by Raj Dayal.
No, remember, can I just ask for a clarification? Has this anything to do with this case? With the case for which he's been paid 15 million?
Absolutely. This is the plaint, one of the 3 plaints. I'm quoting from one of the 3 plaints. That's paragraph 20 of the plaint, where the 1 billion claim, which has resulted in a gratuitous payment, ex gratia payment of 15 million. In the plaint, Raj Dayal says, on 11 January 2018, I received a letter from Mr. Gunpat, Secretary to the President, dated 7 January 2011. Very important, the date. 7 January 2011. And what did the Secretary to the President, Mr. Gunpat, write? And I quote, because this is verbatim taken from the plaint with summons, so that the whole population knows what goes on in this country. 2011, we were not with Rambulan 2011. They were. They were in alliance with Rambulan. They were. So this is what he said. This is what Gunpat, the Secretary to the President, said. This is what he said, and I quote, I wish to inform you that the judgment of the Supreme Court dismissing the appeal against the ruling delivered by the Intermediate Court, this is what I've just cited, this case. I wish to inform you that the judgment of the Supreme Court dismissing the appeal against the ruling delivered by the Intermediate Court does not constitute valid grounds for the President to intervene, as your removal from office of the Commissioner of Police was validly effected in accordance with the provisions of the Constitution. That was on the 7th of January 2011. Who was President of the Republic then? Who was the President of the Republic then? The President of the Republic said, I'm not going to entertain. I'm going to entertain because you were dismissed in accordance with the Constitution. Rightly so. Rightly so. This is why we, MMM, we are consistent. What you said in 2011, you should not have changed it in 2018. 2011, you refused to compensate. 2011, you refused to compensate. 2011, you refused to compensate. Oh, is it? Oh, is it?
Order, please.
Oh, am I to take it? So am I to take it, therefore, the position of the President, his notion of justice depends on who is his partner in alliance? Am I to take it that in 2011, when the Prime Minister was Navin Chandra, the best Prime Minister, the other one was raising the flag at the by-election? Who's? Then no compensation for Honorable Dayal. No compensation for Dayal. No, Dayal was removed in accordance with the Constitution. Sorry, we cannot intervene. Sorry, we cannot intervene. And I have to say, rightly so, Madam Speaker.
Order.
Rightly so. Rightly so. You cannot have different judgment. You cannot have a different scale of justice depending on who are your allies. Madam Speaker, much has been said about the Public Officers Protection Act. Much has been said about it. I don't propose to take too much time out of this House because I think it is a legal issue. It is a legal issue, and in my humble opinion as a barrister, I think that the objection was very well taken. The Honourable Attorney General stated that there was a letter which was given by the former Commissioner of Police making an offer of 5 million rupees. That offer was rejected. Honourable Dayal, in May 2014, entered his cause of action, and then the state, on the advice of the State Law Office, took the preliminary objection that it was in breach of the Public Officers Protection Act. The Public Officers Protection Act is a very inhumane and unfair act because its wording are mandatory. There is no place for any interpretation. If you have not served the civil and criminal suit within 2 years from the date of the fact, of the act or the omission which has given rise to the action, suit, or the proceeding, under pain of nullity. And the Law Commission has criticized and has made recommendation for the law to be changed. The law has not been changed, and I will just quote, which I think from a decision which I think summarizes the situation well. It's a decision of Justice Fekna in a case last year, Ramnarain, Ministry of Health, 2017, SCJ 320. He reviews all the case law, and then he says, the Law Reform Commission has, in a discussion paper entitled Access to Justice and Limitation of Action Against Public Officers and State, suggested, among other proposals for reform, changes that was made in England. However, the hard fact is that such proposal lends support to our interpretation of the law as it has been laid down by Parliament, and therefore, while commenting that the fairness of Section 4 of POPA may be a matter for the consideration of the Law Reform Committee, the learned judge applied the reasoning in the case of Mangru and uphold the plea in limine litis. So, unfortunately, Madam Speaker, there's been a lot of unfairness. There have been cases where people have rightly argued that, I didn't know at the time the surgery was carried out, the medical negligence was carried out, I didn't know there was a medical negligence. But as soon as I found out about it, that's when I entered the action, and therefore the action should start from the day I become aware of my course of action. As it is the case in England, unfortunately, systematically, the judges in Mauritius have said, unfortunately, we can't do anything. There are people who've been claiming millions of rupees who've lost, because this is a statutory provision. And the Honourable Ratna, again, he took I think it's very unfair, because there's a lot of non-lawyers in Mauritius. He quoted from a book, rightly so, that a mise en demeure, admission, stop the prescription, stop which is true, which is correct. Civil prescription is stopped, which is correct. I don't have any problem with that. But it only stops or interrupts a prescription which is ongoing. But if the time is over, if the 2 years is over, even if after 10 years, after 15 years, you decide to make an offer, it doesn't have any impact on the clear wording of the court, which says that it is 2 years from the date of the facts. So the facts which grounds the Honourable Dayal, the facts on which he grounds his action, was not that last year, in 2013, I was made an offer. No, he doesn't say that. When he particularized all his points, why he is claiming 1 billion rupees, he doesn't mention, I'm claiming 1 billion rupees because last year the Sector has agreed to give me 5 million rupees. No, he doesn't say that at all. What he says is that, I have been unfairly removed as Commissioner of Police, and this happened in 30th of January 2000, 18 years ago, or 14 years before he entered his case. And it is also not correct. I think it was the Honourable Vincent Mentor, who said that he waited for this case of appeal against the intermediate court judgment to be over, that he started suing the state. It's not correct. I have a judgment here. Dayal and the state reported in 2007, 7 years before. He was still claiming money from the state. 2007, Supreme Court judgment 310, and in this case, the judgment was delivered on 16 November 2007. And this case is very important, Madam Speaker, and this is why I don't understand how State Law Office and the Honourable Attorney General, in the light of this case, agreed to a settlement. What happened in this case? Honourable Dayal, well, he was just Raj Dayal at that point, he sued the state, and he entered the wrong case, and he moved to amend. He moved to amend the pleadings, and he said that, it was through infelicitous drafting that the words Commission of Inquiry was inserted in paragraph 8, when the plaintiff did not, in fact, mean Commissioner of Inquiry, but meant the state. So he tried to amend the plaint after it was lodged. And the judge upheld the objection to the amendment. And you know what was one of the grounds? One of the grounds? I'll read it. I'll read it, and it's good that the Attorney General, as a legal advisor, hears this. I do not allow the amendment for the following reason. 1, and then 2. It will cause prejudice to the defendant, to the state, in that the delay provided under Section 4.1 of Public Officers Protection Act for instituting proceedings and the requisite prior notice in that respect would not have been observed by the plaintiff in respect of the new cause of action. There is a decision. There is a decision where this point was already taken. And following the point taken by the defense, by the State Law Office, Dayal removed his case against the state. So now what he does is, he sees, who is in power. Will I get my boot? I try my luck. Now, the president doesn't want to give me something. In 2011, in 2013, let me try 2014. Now, 2018, yes, finally I get it. Jackpot, 15 million. Madam Speaker, I started my intervention. Madam Speaker, I started my intervention by saying that it was good. It was good that this motion came before the House, because at least even myself, I have been enlightened about a lot of things which I didn't know. And I have to say that, were it not for this motion, I wouldn't have gone and do all the search that I've done and found at what extent, governments come and pervert facts. Whenever it suits them, they say that it is well taken by the president was right to dismiss him and we can't intervene. And whenever it suits them, say, it was the act of, I was victimized. And why this was very important? Because the Honorable Attorney General, when on the 2nd of June, 2018, he went and called a press conference. This is what he said. Selon, I heard the recording, but I'm just going to quote in French. Raj Dayal a été une victime de l'ancien régime, puisque la décision prise à l'époque de le revoquer était purement bancale. Purement bancale. So, only on that point, Madam Speaker, the Honourable Attorney disqualifies himself. Who is calling bancal? The Discipline Forces Service Commission, which referred the matter to the President of the Republic? The President of the Republic who constituted the tribunal, was that bancal? Was Honourable Soumer Lala, Chief Justice, Honourable Matadine and Honourable Lam Shaning bancal when they recommended the removal of Honourable Dayal? Was the President, when he acted in accordance with Section 93 and removed the Commissioner of Police, bancal? Or was the Secretary to the President in 2011, when Mr. Ganpat, when he wrote to Mr. Dayal and told him that, everything has been done in accordance to the Constitution, the President cannot intervene? Bancal? So, Madam Speaker, I find it very troublesome, very sad that, people was clapping, applauding. I can understand that now Raj Dayal is part of their mix. But we should not forget that there have been reputable judges who have recommended his removal as Commissioner of Police. There have been cases before the Supreme Court challenging the finding of the Commission of Inquiry, which has been set aside on most grounds by the Supreme Court. And, Madam Speaker, another thing I learned, and I will end on that, which troubles me a bit, I have to admit. It is what the Honourable mover of the motion mentioned about the conflict of interest. I don't have any problem with Mr. the Attorney General having been a member of a state law office and having conducted the case in favor of the state before the tribunal. I don't have any problem with that. I don't have any problem with in his capacity now, he's advising the government, although I think that in his capacity, having known what has happened before the tribunal, he was duty-bound to inform Cabinet that 3 judges, 2 Chief Justices, founded and recommended the removal for cause, for misbehavior, which is not a simple thing, for misbehavior. But what I find troubling, Madam Speaker, is that the Honourable Attorney General conceded that he acted for Raj Dayal in a case, which he boasted that he won in advance. But isn't that a conflict of interest? Aren't you supposed to at least disclose it and say, I need to tell you, I'm advising you, but he's also my client. I don't know if he has been paid for his services. But you know what is worse, Madam Speaker, which is more troubling me, is that if ever what he did was unethical, if ever there was a breach of the code of conduct for barristers, if ever in a situation, because all barristers know, whenever you feel that you are in a position of conflict, you have to disclose it. You have to disclose it to the parties, get the consent of the parties to act. So if ever he had breached that provision, you know what is disturbing, Madam Speaker? Under the Law Practitioners Act, it is the Attorney General who has to inquire. And then if he feels that there is any grounds, then he refers it to the appropriate, authorities, whether it's the Bar Council or before the Supreme Court. So, all this you know, as I said in the beginning, Madam Speaker, we don't have anything personal in the Honourable Member, but when I see the way this case has been handled and what I saw today, the way this House is clapping and applauding the payment of 15 million rupees to someone who has been removed as Commissioner of Police, I think that not only the Attorney General, but the whole government should have been the subject of a motion of blame, of no confidence in this House. Thank you.